Hello aspirants, looking at current affairs for 28th November, the news items picked up from the Hindu newspaper are these 11. We'll look at them in detail. The first one, Supreme Court sends Hadiya to Salem in Tamil Nadu to pursue her studies. So this is the case of 25-year-old Hadiya, whose earlier name was Akhila. So she has converted to Islam and married one Shafin Jahan. She's from Kerala. The Kerala High Court had actually annulled the marriage. The case went into appeal in the Supreme Court, and the Supreme Court has asked the NIA to investigate into the matter, the National Investigation Agency, because it was alleged that there is a systematic conversion taking place in Kerala, and these people are indoctrinated as such. So the terror angle as such is also being looked into. Though terror angle has not come to the fore, but yes, conversions are taking place is what the NIA mentioned in its report. And the Supreme Court has now for the first time asked Hadiya to be present for it in New Delhi to give a statement. And in this, she said that she has been kept in unlawful custody for 11 months. Her statements were not taken so far. She was studying homeopathy and she wants to complete her 11-month internship to become a homeopath, and the Supreme Court has asked her to go ahead with it. It directed the college to allot her a hostel room as well. So this is the case. The issue of actually before the Supreme Court was whether the NIA report should be discussed first, the material produced by the NIA, or Hadiya should be interrogated first, or Hadiya should be issuing the statement first. The statement should be heard first. So here the Supreme Court went ahead and heard Hadiya, and it was alleged by the Additional Solicitor General representing the government that Hadiya is among the 11 cases that NIA is currently probing on radicalization in Kerala. So the court said that this is the Attorney General said in the Additional Solicitor General said in the Supreme Court that she is a programmed individual. So her consent that she has done it on her own free will cannot be taken. But then the Supreme Court mentioned that even in case of indoctrination, the law and courts cannot intervene against the free choice of a person. She has her own free will, and that cannot be imposed on her, so taken away from her. So this is the issue before the Supreme Court presently, and a hearing has been done now. Then next is Constitution Bench likely to take up petitions challenging Aadhaar linkage scheme. So the CJI has said that he will soon be listing the number of petitions which have been filed challenging Aadhaar schemes before a constitution bench. So a 5-judge constitution bench is going to hear on this matter. Already a 5-judge bench is hearing the matter on Centre-Delhi relations. The central government and the Delhi government power tussle over administration. So after this is concluded, the 5-judge bench will go ahead with the Aadhaar cases is what is likely. There is a need for hearing on Aadhaar scheme in urgency because even deadline for Aadhaar bank account linking is coming close, that is 31st December 2017, and also Aadhaar mobile phone linking deadline is 6th Feb 2018. So earlier actually in Aadhaar case it has been decided that it will be referred to a 5-judge constitution bench, but before that the issue of right to privacy, whether the right to privacy is a fundamental right or not, on this a 9-judge constitution bench was appointed and it gave its ruling in August 2017 calling right to privacy a fundamental right. So now after this has been clear, now Aadhaar case can also go ahead before the constitution bench. So actually now the question would be whether Aadhaar data collection means right to privacy is a fundamental right, of course with reasonable restrictions. So is Aadhaar data collection reasonable restriction or not? So whether it is violating right to privacy or is it reasonable restriction on right to privacy? So this will be a point before the 5-judge constitution bench. And the second is, can it be made mandatory? Can Aadhaar be made mandatory for number of services? Like if you don't link your bank account with Aadhaar, you cannot access your bank account. So can Aadhaar be made mandatory is the second question which this 5-judge constitution bench will hear and give its ruling. So this is regarding the landmark right to privacy order of August 2017. So this 9-judge bench said privacy is a fundamental right. No policy or law can take away privacy completely. Only reasonable restrictions can be imposed on grounds such as security. So even data protection law is required has also been highlighted in the ruling. Also, collection of information in digital space, whether it violates right to privacy or not, is also being put up as an issue. Then also implication of banks, e-commerce and apps that collect personal data. The implications of this is also an issue. And also homosexuality. Homosexuality also is in the domain of right to privacy. So the ruling makes it almost certain that homosexuality will also be decriminalized. And verdict strikes down the state's power to suspend civil liberties during emergencies. Right? Also, it can have impact on right to convert and choice of food. So this is the landmark ruling of the Supreme Court on right to privacy. The key points again highlighted here. So it will have impact on cases like Aadhaar, WhatsApp, privacy case, even homosexuality, euthanasia. That is an individual's right to refuse life-prolonging medical treatment. Okay? And then abortion, a woman's freedom of choice, whether to bear a child or abort. Then next is new gas standards in the works to fight pollution. So the Central Pollution Control Board has its guidelines in place. It has guidelines for maximum permissible levels for 12 gases and pollutants, depending on whether they are in residential, rural or industrial locations. So this is already in place, but the Central Pollution Control Board is looking to revising these standards. And CSIR, Council for Scientific and Industrial Research's laboratory, National Physical Laboratory, is setting up gas standards. So there will be gas standards for various gases, that what are permissible levels for emissions. So for carbon monoxide, sulfur dioxide, nitrous oxide, even particulate matters like lead, arsenic, nickel, it would give its standards. So these gas standards, actually the current gas standards are national ambient air quality standards. So they give upper limit for various pollutants, and based on this air quality index is also formulated. So this is going to see a revamp now. Government also wants that all agencies should use accurate instruments. So a unified testing methodology would be prepared. So this is the present national ambient air quality standard. So for different pollutants, you can see the ambient air permissible limits are given for industrial, residential, rural areas, and also for ecologically sensitive areas. Then next is a long journey from Thalassery to the Swiss Parliament. So this is Mr. Nick Gugger, who has been sworn in as a member of National Rat. So this is the Parliament of Switzerland. So he is a 47-year-old father of 3 children. He has been elected to Swiss Parliament as a candidate of Evangelic Party in Switzerland, and he is an Indian by birth. He was adopted by a Swiss couple from an orphanage. So he, a person of Indian origin, now being elected to the Swiss Parliament is news. Then next is Naga talks still on, panel told. So this is the Naga interlocutor, the person appointed by the central government to hold peace talks in Nagaland, Mr. R.N. Ravi. He has been presented before the Parliamentary Standing Committee on Home Affairs and been questioned, and he has said that no deadline has been fixed for the Naga peace agreement, and talks are on with at least 5 to 6 Naga groups other than NSC and IM. So this issue has been in news quite often. NSC and IM is one faction of NSCN. NSCN-K has not come for talks. It has violated the ceasefire agreements earlier and it's not ready for talks presently. But NSC and IM faction calls itself the legitimate Naga group, and it has said that negotiations should take place only with it. But the government of India, the central government, the interlocutor says, wants talks with other factions also. So NSC and IM and the central government signed an agreement, a framework agreement in August 2015 at the residence of Prime Minister Narendra Modi. So this framework agreement was signed, but then the details of this agreement have not come out in public, and that's what the Parliamentary Standing Committee on Home Affairs wanted to know. But then the interlocutor says that that has not been finalized yet. Even Mr. R.N. Ravi has been given an extension of 1 year by the central government too, and he says that talks will go on with all other groups, and then after finalization things will be put before the Parliament. So this is there. NSC and IM has demanded for Greater Nagaland or Nagaland. So even the peace framework agreement, it has been stated quite often that are close to finalizing the agreement, but nothing has come out in public. and the parliament also wants to know about it. So this demand of NSC and IM for Greater Nagaland or Nagaland is extension of Nagaland's borders into Naga dominated areas in neighboring states, that is Assam, Manipur and Arunachal Pradesh. In all three states, Assam, Manipur, Arunachal Pradesh are BJP ruled states. They have Naga population, but they refuse to part with any part of their land for a peace deal. So then the central government is in a fix presently. So demands cannot be accepted. So this is the issue here. Then next is can't force government to frame a law, Supreme Court. So the Supreme Court has been approached, a petition has been filed asking it to ask the government to ratify UN Convention Against Torture and also have a standalone anti-torture legislation. But the Supreme Court says that it respected the government's political compulsions and it would not compel it to ratify this convention or command it to frame a standalone anti-torture legislation. So this petition, which had been filed almost a year ago, has now been disposed of. So this is there. So you should know about UN Convention Against Torture. This was signed by India in 1997, but it has not been ratified by India yet. And also on the standalone anti-torture legislation, the Law Commission has already recommended to the centre to ratify UN Convention Against Torture also and frame a standalone anti-torture law. So a proposed law, Prevention of Torture Bill 2017, has also been put forth by the Law Commission in October 2017. So it defines torture and also gives various provisions under this bill. So the Law Commission has also said that the government cannot claim immunity for the actions of its officers or agents. So torture is on by an official. So be it in police force or by the military. So torture has to be dealt with sternly and government has to take responsibility for it. So that is what the requirement is. The government also, the Attorney General, K.K. Venugopal, he has also intervened to submit that the government was considering an anti-torture law. So this is the issue. Here you can see the UN Convention Against Torture, which was adopted in 1987, is shown. The countries which have adopted it, signed it, and countries which have ratified it. You can see India has not ratified it, though it has signed it. So this convention defines torture as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected to having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind when such pain or suffering is inflicted by or instigation of or with the consent of a public official or other person acting in official capacity. So that is the definition of torture under the UN Convention. So if it is lawfully sanctioned, it is not included. So torture is that which is not lawfully sanctioned. Then next is October GST collection slipped to 83,346 crores amid tax cuts. So the GST collection for October month have dipped compared to September. So September it was 92,000 crore and now it is around 83,000 crores. So this dip in the tax collection, it has been said, has been due to the drop in the additional integrated GST collections also, and also because of the reduction in GST rates which have taken place. Also, the other reasons given is that the compliance level has also reduced. So you can see tax compliance may not be up to the mark, and there are other key steps which need to be taken, like matching of returns, e-way bills, reverse charge mechanism. So they have been postponed. So the issues are still there and we are seeing GST collection dipping. So we saw recently also that GST rates have come down. Okay. Taxes on most commodities have come down. So this is the issue here. You can see the collection for October as compared to the collection earlier. So the center and state government's share in GST is shown here. So integrated GST is actually shared. Central GST goes to center, state GST to states, and a share of IGST goes to each one of them. And this is a compensation provided by the central government. So the total collection is shown for July to October here. And filing of GSTR 3B, the last GST form. So this for each month you can see there's a dip in compliance also. Then next is India eases bilateral transfer pricing norms. So the Income Tax Department has issued a clarification presently saying that now it would allow mutual agreement procedures and advance pricing agreements with all countries. So mutual, you should know what is this mutual agreement procedure and advance pricing agreements. Advance pricing agreements are actually to settle potential disputes in advance. So if there are any disputes which are expected in taxation, so they are resolved in advance. So the two parties, the government and the party which is to pay taxes, will come to this advance pricing agreement. So it is in advance, both the parties would know what is to be expected. And mutual agreement procedures, these are procedure to settle a dispute once it has happened. So these two forms of agreements actually are done with various countries by India, and India had previously stated that any transfer pricing dispute would be settled through domestic legislation instead of bilateral arbitration. So this has been India's stand, but now it has agreed that advance pricing agreements and mutual agreement procedures would be entertained regardless of whether it is there in the treaty or not with various countries. So even with countries like major trading partners like France, Germany, Italy, Singapore, South Korea, which which do not have such provisions under their agreements, bilateral trade agreements, still India would allow MAPs and APS for them. So this is a change in stance which the government has done presently to improve ease of doing business. So here you can see. So these are bilateral advance pricing agreements. They will benefit, of course, the multinational corporations. So if a tax treaty with another country does not contain a provision of corresponding adjustment in matters of transfer pricing, the government will still entertain bilateral MAPs and APS. Right? So there is no need to amend tax treaties as such presently. Government is going to allow. The government of India is going to allow it. Then next is N.K. Singh is 15th Finance Panel Chief. So the 15th Finance Commission was proposed to be announced, and it has been announced now. Former Secretary to the government, Mr. N.K. Singh, has been appointed as the chairman of the 15th Finance Commission, which will make its recommendations for the 5 years from April 2020 to 2025. The other members are also mentioned here. The task is to look into tax collection and how it is to be divided between the center and the states, the principles that should govern the grants and aids which is provided to the states, and also review the levels of fiscal deficit. And other matters are also there before this Finance Commission. So this 15th Finance Commission has now been appointed. Then next is infrastructure status, a first step for logistics. So we had discussed this. It had been in news that logistics has been given infrastructure status, and now after this there are other steps also required as mentioned by the industry. So DTDC Express, which is a leading courier brand. So logistics is basically in movement of goods as such. So this company is giving its viewpoints on how infrastructure status to logistics industry is only a first step, and there are more problems which need to be resolved, like there is proper regulatory oversight required, there is requirement of skilling the workforce in the sector. So there is not enough infrastructure to train them is an issue highlighted as such too. There is a need for standards because small, large companies all are competing without adhering to the same standards. So they compete for the same set of customers. So standards should be there, regulation should be there is highlighted. Also with respect to GST, the e-way billing system is also highlighted, which though has not been implemented as of date. It will be rolled out nationwide from 1st April 2018. But this e-way billing system, it's timed at tracking the transport of goods worth 50,000 or more across the country. So there is improvement required as such, which is demanded by DTDC Express. So this e-way bill actually is generated, you should know. Here it is shown. So an e-way bill would be generated, means supplier to the person, there will be a supplier, a purchaser, and a transporter, 3 entities involved. So when transportation is taking place, so a supplier will generate this. It will provide the details of the transporter details as such in the form, and based on this, a e-way bill would be generated. So when this e-way bill is generated, then supplier, purchaser, transporter all will be sent this e-way bill number. So purchaser will have to accept this e-way bill details, and also in transit, if the lorry changes due to any circumstances like interstate or interstate issue or even accident as such, new e-way bill will have to be generated. So this e-way billing system is there, you can see. So the transfer from a conveyance from one place to another will go through this e-way billing system. So this here, the issue which is highlighted is that e-way bill validity, there's a time limit set on the validity of the e-way bill according to the length of the trip. So exceeding that, then e-way bill has to be renewed. But then the logistics company says that there are many a times when some circumstances which are beyond their control, like what happened in Delhi is given as an example, when government banned entry of trucks in its border during the time when the pollution levels were high. Then who will be penalized in such cases, the transporter or the customer? So these are some questions. So that's why there is clarification required on the e-way billing system too, which is demanded by this logistics company. Then next is S. Durga screening at IFA is still uncertain. So this is another movie which is in the center of a storm, that is S. Durga. So the screening of S. Durga at the International Film Festival of India 2017 in Goa is still uncertain. A jury has been appointed by the Indian Panorama section, and its decision, it is said, will be conveyed to Ministry of Information and Broadcasting, which will convey it to further to the Kerala High Court too. But then the film festival will wrap up soon too. So this is a major issue here. Actually, INB Ministry decided to drop S. Durga from the original lineup of movies to be screened during the International Film Festival. S. Durga has already won Hivos Tiger Award in the International Film Festival in Rotterdam in 2017. So this movie earlier was named Sexy Durga, but then it has been renamed as S. Durga now because of protests. The Hindu organizations claim that the film has targeted the Hindu goddess Durga and denigrated her, and in the process hurt the religious sentiments of Hindus. So it's a movie regarding a horrifying experience of a hitchhiking couple. So they are on a road trip and they are having this horrifying experience with two men in the dead of the night. So that is the whole story, and it has won critical acclaim but is not being screened presently as such. So this is the controversy. So these are the news items. Thank you.